Bien, buenas tardes a todos. Gracias por su interés y su tiempo en este primer webinar que estaremos realizando, auspiciado por TMA Chile, Carey y Fix Partners. Hoy hablaremos de un tema extraordinariamente relevante, ¿verdad? Que es cómo cross-border insolvency puede de alguna forma generarse y generar que algunos países puedan ser verdaderos modelos en cuanto a procesos de insolvencia. Dado que es un tema, yo diría, internacional, la exposición la haremos en inglés, así que voy a cambiar ahora a inglés para poder presentar a nuestros speakers y también quien va a ir moderando la discusión. So I'm going to switch to English. Good afternoon, everybody. Thanks for joining our first webinar of 2021. So on behalf of TMA Chile, Carey and Fix Partners, welcome to everybody. TMA, Turnaround Management Association, is the most professional, diverse organization corporate restructuring, turnaround, and insolvency procedures. Established in 1988, TMA has almost 10,000 members in 24 chapters worldwide. Members include turnaround practitioners, lawyers, accountants, advisors, liquidators, consulting, academic, government employees, and court members. Today, we will discuss cross-border insolvency and the key elements that might exist in a determined country to become a world-class venue for bankruptcy cases. So please, let me introduce our keynote speakers. Mrs. Susana Hidbegi. Ms. Hidbegi is a lawyer from the University of Rosario and LLM in bankruptcy from UCLA, United States. She's a professor at the University of Andes, Colombia, and the current chief bankruptcy judge of Colombia. Also welcome to Mr. Hugo Sanchez. Mr. Sanchez is a civil industrial engineer from the University of Chile and an MBA from Este Business School. He is the current Chile insolvency superintendent. Also, Mr. Rafael Saraldin. Mr. Saraldin is a Bachelor of Science at the University of Virginia, Juris Doctor at the University of Delaware Law School, and LLM from Georgetown University. He's a partner at Strong Tisdale office. Also, finally, I want to say hello to Mr. Ricardo Rebeco, partner at Carey, who will lead the roundtable discussion at the second half of the webinar. Please, Susana, go ahead.
Good morning and good afternoon, everyone. Thank you for having me here as the superintendent of bankruptcy proceedings in Colombia. I have had the chance to see a lot of developments these days, and one of the purposes of this conference is to share with you some of the experiences that we have had and how Latin American countries, especially Chile and Colombia, have been developing a lot of solutions and framework for these specific situations. So I'm gonna go through some of the specifics in Colombia. And of course, at the end, I will be very happy to answer any questions you may have. So can you confirm that you are now able to see my presentation, Rafael?
Yes. It's
okay. Thank you. So I would like to share with you this overview on the Colombian bankruptcy system these days. This is December 2020. This is how the insolvency proceedings are distributed in our country. We have about 3,465 insolvency proceedings, including reorganization and liquidation. And here is how they are distributed around the country. Of course, we are a small jurisdiction, but With the COVID crisis, we have had more proceedings going on these days. So I would like to point out some of the specific situations that make Colombia and Chile in the head or in the region as very developed jurisdictions for bankruptcy. So in Colombia, first, we have a specialized bankruptcy court. I would like to show how we work with bankruptcy as an independent system. So here in Colombia, we have the bankruptcy court is part of the executive branch. So we are part of the government, not the judicial branch. And as that gives some flexibility, we structured the system in a way that we are not only specialized bankruptcy court, but we are structured in a way that the judges are specialized in each type of insolvency proceedings. So this is the main structure that we have at the Superintendence of Companies. I had that in Spanish and English, so it's easier for you to understand. So we have a specific group of people working on the study of the petitions, which is admisiones or admissions. Then we have a group specialized in we have it in categories or types, depending on the amount of assets. So A, B, and C. There is a group devoted to the A proceedings, reorganization and liquidation. We have a group with a judge specialized in pre-packs and out-of-court plans. We have some groups called directions. This is a group devoted to reorganizations of type B proceedings. And then it's a direction for C-type reorganizations, and it has some groups. One is devoted to small reorganizations that commenced under the former law, and there is a specific group for summary reorganizations. We have these as part of the COVID legislation. It's a small businesses insolvency proceeding specifically for reorganization and liquidation. Then we have a direction in charge of following the fulfillment of the plans, and then that direction takes the type B plans, and then there is a group specialized in following the fulfillment of the agreements of type C. Then we have another direction in charge of B-type liquidations, and then another direction in charge of C-type liquidations. It has a group specialized with a specific judge in simplified liquidation. So as you can see, we are as specialized as it can be. This works like as an industrial production system of the bankruptcy court. So what else I want to share with you? We have, as we are now speak a lot in medical terms, we can say that Colombia has a broad spectrum insolvency regime. And when I say this, I'm referring that we have a lot of different type of proceedings applicable to each type of problem. So it's not about that one solution suits all. We have different type of reorganizations. We have the ordinary reorganization for mid-size and up entities would be the B and the A reorganizations. And we have the small businesses reorganizations for the C type of procedures. We have also pre-packs. These have been in place for more than 15 years. And we have now out-of-court reorganizations. It's different because with the pre-pack, you have to go with a pre-arranged agreement for confirmation. And with the out-of-court reorganizations, there are two types of procedures. An emergency negotiation. Basically, the debtor files a petition to commence this expedite reorganization negotiation for 3 months. And if an agreement is reached, then it could be confirmed by the court to make it binding for dissenting creditors. And there's another proceeding called recovery, and it's done before mediation centers. So it's possible to go through an out-of-court mediation to try to reach an agreement with the creditor. So with this, I could say that we have like at least 7 procedures to reach a reorganization plan. And we have liquidation. We have also specific type of liquidation procedures for mid and up companies and for small businesses. So that's why I talk about broad spectrum system, because there it has, or it pretends to have or intends to have a solution for each of the problems. We also have some specific features that make our system somehow related with something that could be familiar to us, that is the Chapter 11 reorganization. So we have automatic stay as of the commencement, not as of the filing of the petition, but it works because it's a civil law country, so we have some specific situations that make it very hard for the culture to assume an automatic stay as of the filing. So it has been like that for a while. We have also initial orders where the debtor can pay some of the obligations with the authorization of the court as an exception to the automatic stay. We have now deep financing in one of the COVID legislations. We also have some dispositions and regulations to allow debt equity swaps. So creditors could end up being owners of the entity. We have a new proceeding called emergency rescue of liquidation that allows, when a company is subject to liquidation, any creditor could bid to save that company and pay just like a rescue price to cover some expenses like labor law contracts and some of that to arrange with secured creditors. We also have discharge in some situations, and we have some regulation on the capitalization of claims. So this new law, and now I would say that the legal environment invites to engage in distress financing and in distress M&A. So that would be my overview on the Colombian system. Thank you.
Thank you, Susana. Mr. Hugo Sanchez, please.
Hugo, you're on mute.
Thank you. Thank you for having me today. I'm very honored to be part of this distinguished panel. And let me tell you some things about our cross-border insolvency system. We had a very big change of law 6.5 years, that it's our current law. And compared with our old bankruptcy law, there was a very big change, not only in the numbers of the proceedings. You can see in this slide, we had only 5,300 proceedings in 34 years of old bankruptcy law, and we have the last 6 years more than 30,000 proceedings. So it was a very good change, especially for individuals that didn't have a specific proceeding to surpass the insolvency state of this financial, and well, other thing that was very important in this new law, this current law, is that we adopted the UNCITRAL cross-border insolvency model law. So our cross-border insolvency law is regulated on Chapter 8, and it's only it has only 32 articles. So it's very simple, but I think that is very useful. Well, the purpose is to provide effective mechanisms for dealing with cross-border insolvency. Some objectives were to improve the cooperation between the courts and other authorities involved, greater legal certainty for trade and investment, of course, fair and efficient administration of cross-border insolvency that obviously protects the interest of all creditors and other interested persons. Is, for instance, that we were looking for in the LATAM airplanes, we were looking for the protections of the national creditors. The protection of debtor assets value maximization, of course, and at the end, facilitation of financially troubled business rescue. But what had happened in Chile, the competent court is the ordinary civil court. You know that we don't have specialized bankruptcy courts. And civil court, you know that they deal with many different civil proceedings. And the superintendency is the legitimate body to act as a foreign representative. We have delegated this power on the administrator, especially on observers and liquidators in many different proceedings in Chile. I want to mention 3 or 4 cases related with Ponzi schemes, frauds, where those companies were liquidated in the Chilean system, and the liquidator asked the superintendency for this power to be the administrator and the representative at the foreign countries like United States, United Kingdom, different islands like Cayman Islands. Cooperation and direct communication between Chilean and foreign courts are allowed. We've been suggested Chilean courts to design protocols to communicate with court to court and with the different representatives for the foreign insolvency proceedings here in Chile. Well, foreign representatives have direct access to Chilean jurisdiction, as I said, and the difference with model law is that Chilean law doesn't incorporate the presumption of insolvency when a foreign proceedings is recognized. I think that is very important. So if an interested person, you know, judicial or individual, wants to start an insolvency proceeding under the Chilean law, it needs to follow the general rules that is to apply to a specific insolvency proceeding here in Chile. If there is no insolvency proceeding here in Chile, the superintendency is not able to audit this proceeding. We monitor all the proceedings that occurs abroad and here in Chile, but if the foreign representative doesn't open a Chilean insolvency proceeding, we can audit and ask for information. The only chance that we have is that the courts informed us or asked for some information that the superintendency has. Well, measures that can be granted since the application in Article 318 is suspension of the debtor assets execution and entrusting to the foreign representative or another person designated by the court the administration or realization of all or part of the debtor assets located in Chile. And those main measures finish when the application for recognition is resolved by the court. And we have the article number 320 that has many different other, not very different, but many other measures similar to the measures that are taken in the filing process. That is suspending the commencement and continuation of individual actions, suspending execution against the debtor assets, suspending the right to transfer, encumber, or otherwise dispose of any assets of the debtor, and many other rules that are in this article. And what happened in practice in cross-border cases in Chile, we have few cases, only 60 cases, you can see in this slide that in the left wing we have the 8 foreign origin cases. I wanted to highlight the LATAM Airlines group because you know that it's on the run, it's a very big reorganization proceeding. And on the other hand, we have the domestic origin cases. The 3, I mentioned that many of them were related with the Ponzi scheme liquidations of those fraudulent companies. And I wanted to highlight the Enjoy cases. That is one of the most popular and big companies related with casinos and gambling in Chile. And well, businesses involved are all of them big transnational companies, except of course those Ponzi scheme companies that the owners had many assets abroad, and they had to be recovered by those liquidators. The recovery rate in liquidations were about 20%, considering the rate debts to assets. On domestic cases, only 3 are currently authorized by the superintendency to act in a foreign country. The majority of foreign cases came from Europe, Spain and Italy. You know that those countries, European countries, have agencies in Chile related with transport, real estate, constructor, etc. LATAM Airlines case is worth to know because although the company's headquarters are in Chile, it was estimated that their COMI, their center of main interest, is located in New York because many different reasons. You know, their main vendors, the main investors, financiers, etc., were located in the United States. Some cases of recognition of foreign proceedings began in Chile as a recognition of as a reorganization of the agency. And once the liquidation was decreed in Chile and in the other foreign country, recognition was requested. It's better known that Astaldi, an Italian company, was at that situation. Well, other tips, very important tips: enjoy the biggest casinos operating in Chile, and LATAM Airlines Group were the most significant case last year. LATAM case is the biggest. LATAM was the first cross-border insolvency case in Chile where Chilean court has adopted a protocol of coordination between courts that we suggested. We were observing this protocol to have the best one of the protocol, and enjoy it. Most of the debt bondholders were located in United States, so it was necessary to apply for recognition of the reorganization in New York to extend the effects to American creditors. And what about Chile as a cross-border insolvency destination? The main figures of the doing business specifically in the resolving insolvency part of this poll, we can see that the recovery rate of Chilean cases is under the average of the OECD high income countries. So we have to improve that recovery rate. The duration average of the proceeding in years is almost above the OECD average too. The cost is significantly high compared with the OECD income countries. And the good news is that the strength of our insolvency framework system is very well in comparison with the OECD countries. So what challenges do we have for the future? is, first of all, improve debtors' financing alternatives. We have a debt imposition mechanism, but I think that we have to improve that mechanism. We have to improve the quality of the insolvency decision-making bodies. We don't have, as I mentioned before, bankruptcy courts very specialized in those insolvency proceedings. Last but not last, we have to extend deadlines and increase the flexibility of reorganization procedures for large companies. Well, some details on each one of these pillars is to improve debtors' financial alternative. One possibility is to give the debtor the power to define its financing, similar to the figure of the debtor in possession in the United States. We were talking recently, and I was attending a webinar related with the critical building blocks for reform and restructuring organized by the World Bank Group. And the man in charge of the financing process in this insolvency proceeding mentioned some benefits to have their center of main interest in the United States. Then they have one collective plan, one unique timeline, bankruptcy specialized courts, very mature insolvency system, liquidity, flexible timeline. So we have to point to these objectives too. On the other hand, the financing market in Chile must also be strengthened. I was talking in the morning with the senior advisor of the Financial Market Commission, and he told me that our bank system is very risk avoider, and there is no, our maximum interest rate doesn't allow rates over, I don't know, 6% a year, and it doesn't, it is not connected with the interest rate that we can find in those insolvency proceedings that are above 10%, 12%, very high over the maximum interest rate. And the other thing is when a company, a business is entering, is during a reorganization proceeding, the Financial Market Commission gives them a risk score, a worse risk score, and they have to make more provisions. So it's hardest for them to obtain more liquidity in our Chilean financial system. We have to improve the quality of the insolvency decision-making bodies, more training and participation of interested parties. We have a communication and training program with our courts. One possibility is to establish specialized insolvency courts. It's very difficult, but we have a similar example in the tax and customs courts. So it's not impossible, I think. We have to extend deadlines and increase the flexibility of reorganization procedures. This gives the parties a greater margin to negotiate. A characteristic of destination for cross-border insolvency, like United States, is that the procedures do not have rigid deadlines. We have only 90 days duration of the organization proceedings. So I think that we need more flexible deadlines to our reorganization proceeding. And this is the last slide. I want to mention that we are amending our law. Today afternoon at the Senate is going to be voted. It passes the deputy chamber 100% of the amendment of our law. And we are simplifying the liquidation and the reorganization insolvency proceedings for small and micro enterprises. We are adding 10 more days for each extension of the bankruptcy financial protection, that it's about 20 more days for our reorganization proceedings. And finally, loans obtained by the debtor during the financial protection will be not considered in the ordinary credits category. They will be paid on the agreed dates, and if the company is declared a liquidation, they will have preference for their payment. This was a gray area that it affected, I think, many of the reorganization proceedings in Chile, and we are clarifying this gray area, as I said. The good news is that, well, we studied all of the reorganization insolvency proceeding in Chile, and we have a coverage rate that is about 74%. And studies in the United States mentioned that there is 79%. We are very close to the recovery rate of the United States. So thanks again for having me today, and I'm very open to all of the questions that you have. Thank you.
Thank you. Thank you, Hugo. Very interesting points that we're going to handle in the further discussion. So please go back to Mr. Saraldin.
Excellent. Good morning. Good afternoon. Everyone can see my screen, I hope? Good.
Yes.
So let's talk a little bit about what happens in the United States with debtor in possession financing. I was fascinated to hear from my other colleagues on some of the distinctions, improvements, the work that's being done there. But let's go through what seems to work in the United States, or maybe some people say it doesn't work. So we'll cover the basic statutory framework for the DIP financing. We'll also look at the structure for commercial transactions in the United States, because they're intimately connected in our system. I'll talk a little bit about the US as a commercial bankruptcy venue, some sources of financing, and then we'll end by talking or looking at Singapore, because it's adopted some very interesting frameworks based on Chapter 11 that I think the audience will find interesting, as well as my other panelists. So the big issue with DIP financing is really cash flow. When you are an insolvent entity, the biggest problem that you're going to have is that you need to borrow money, but you have a restriction because of your condition as a distressed entity. Here in the US, there is a market to lend money to a debtor in bankruptcy and make a return. That's the biggest piece of this. There is a structure in the 1978 code that created and then helped facilitate that market. There's an absolute priority scheme for payment of creditors here. The absolute priority rule says that no one in a part of the scheme up top can be paid below until the top is completely satisfied. So secured creditors have the highest priority. Administrative and priority claims, which are either special claims determined by Congress to be paid first, or claims that go to help finance or move the bankruptcy forward, are given second priority. Then unsecured creditors, which will include, oftentimes, with the exception of some small priority claims for employees, unsecured will include most of the employees, trade vendors, government entities, taxes. And then, of course, equity is last here, because if you're insolvent, there's nothing to give the owners unless something happens during the bankruptcy case. All this is found in Section 364. There are 4 sections. We'll go through each one of them. This is the authority of how to get a credit or a loan. You have to ask for permission from the court to get into a new financing situation. And we'll go through each one of these. So the debtor in possession, known as the DIP, must show the court that financing was not available with one of the lower priorities in the scheme. The DIP must show that the court that it made an effort to get financing on less onerous terms and was unsuccessful. Practically speaking, this is pretty easy to do. If you go out to the market and you ask a loan for a distressed entity, guess what? You're not going to get it usually, and you're not going to get it at a competitive rate. So then you have to go to alternative financing. The first section is 364A. This is really protection for people that are trading with the debtor, post-petition trade vendors who are extending credit terms. If the DIP borrows in the ordinary course of business, then the lender's claim, which would be someone that gives you a 30-day time period to pay you back on supplies or raw materials, they get a first priority administrative expense, which is the second level of priority in our priority scheme. 364B says that if it's outside the ordinary course of business, you can get an administrative priority as long as you ask for permission from the court. Most creditors tend to only lend if they're actually lenders with, if they're secured. This is not used by traditional lenders. This is normally loans from affiliates. It could be a parent company or a holding company. We have a current case pending in Delaware right now, not one of my clients, but that's just pending, where 140 or so nursing homes had 2 or 3 that were hit by a heavy regulatory fine under a key TAM as well claim, $300 million or so. So the larger holding companies segregated those companies, put them into bankruptcy, and they're providing loans based on a unsecured basis. Under 364C, if you can't get unsecured credit, you can get what's called a super priority administrative claim, which means that you'll be in the number 2 category, but you'll be ahead of all the other special payments. You can also get a security interest in unencumbered property, property that does not have a prior collateralization, a prior financing statement. Or you can take a subordinate, a second lien position in unencumbered property. A lender often gets both of these protections. The toughest and the most protection is where you get a security interest that's senior or equal to an existing security interest. So if someone was giving an operating loan to a company and you want to come in and fund the bankruptcy, you have to go to this particular section if you want to get security, and most banks will not, or most lenders will not do it without that. A priming lien is a DIP loan with a lien that's senior in priority to existing pre-petition liens. This is an extraordinary protection for a post-petition lender. The lender whose lien is primed, the one who had the position pre-petition, has to be protected in some way, either through replacement liens or some sort of payments. And a priming lien fight is difficult to win, but not impossible. But usually this is an agreement between lenders, sophisticated lenders. One who says, look, I don't want to put any more new money in, but I want to protect the money that I have in this company already. So whether it's going concern value or some sort of other objective, they're willing to agree with certain protections to get primed and allow new money to come in. The reason all of this works is because you have a basic protection for commercial transactions in the United States. The Uniform Commercial Code is adopted by all 50 states with little variation. It does a lot of different things which are listed on the slide. I won't go into those in detail, but the important thing is that most UCC transactions involve secured property financing by a bank or a lender, where the title to the property is held as security until the loan is paid. This is a very important aspect because it really does mesh in with the DIP financing. Under the UCC, the lender has a security interest only if they perfect against third parties, only if they perfect by filing a financing statement with the appropriate registry. Most business entities file in the state where the entity is registered. For many businesses, that's Delaware, with 66% of the Fortune 500, more than 1 million entities, both U.S. and international, that are registered in Delaware. So the way these two things put together is that security agreements typically give you a security over all of the inventory, accounts receivable, the proceeds. So when inventory becomes accounts and that becomes cash, and then new inventory, the lien floats and follows all of that. In a Chapter 11, the debtor can't operate without cash flow, but it's restricted from using the encumbered cash without permission of the secured creditor or a court order. But that's the way that this works, is the court often gives permission. So there will be a combination of being given permission to use the cash coming in, plus getting new cash, as long as there's a negotiation. And he provides a framework it provides an opportunity for the parties to come together, and it facilitates usually a consensual use of cash collateral. One, because cash collateral is often granted, and two, because it is rare to have a contested dip or a priming lien, because this encourages a settlement or encourages coalitions to help get money into the court. There's an immediate need for cash, so this happens at the very beginning of the case. What they will do is, as soon as the automatic stay comes into place, you're allowed to go in. Oftentimes, in most jurisdictions, it's within 48 hours. You have a hearing. It could be sooner if it's an emergency. You then will get permission to get into a loan that will sustain you for a certain amount of time. Maybe it's 4 weeks, maybe it's 3 weeks. It's usually on an interim basis. It's very easy to get that financing because you have to simply show that there'll be irreparable harm if you can't pay your employees or vendors or other folks. And again, if you are insolvent, you're going to have problems with cash flow. It's very important to develop a budget that is then shown to the lenders, to your prior lender, your new lender, or if it's both. And even if you don't have that, you still need to show that budget to the court in order to get that approval. But again, it's going to be based upon the exigencies of the financial situation. So why does this all work? Well, we like the system here because they're specialized courts. There's a problem-solving focus in the courts that are most popular here in the United States. And there's a unity of purpose usually between the bar and the bench to have those two things be there. The specialized court piece is easy because of the way our Constitution is structured and the bankruptcy code is structured because the bankruptcy courts have a limited jurisdiction. But this has been perfected in places like Delaware, the Southern District of New York, the Eastern District of Virginia, and Richmond, and federal courts in Texas, mostly because they looked at the Chancery Court in Delaware, which is a specialized business court because of the large number of corporations that come through in the United States through Delaware, and which really had a focus of problem solving as well as a very, very high rating in terms of their professionalism and knowledge. But they're also very, very user-friendly. That's also part of the problem-solving focus, and the judges there have been known, and so have then in following the bankruptcy judges, of putting their vacations on hold and keeping their courts open until 3 or 4 in the morning until they resolve an issue that's important to the parties. What is the sources of DIP financing? Well, in 2019, DIP financing volume was more than 18 billion compared to about 10 billion in 2018. These are very large numbers just for DIP financing in the US. These are normally secured creditors who provided secured loans or unsecured debt pre-petition in the form of bonds or other debt, and they lend to enhance their own recovery. They can also be parties that lend for investment and more strategic purposes. This is sometimes called loan-to-own transaction. But with the pandemic, we've seen a rise of strategic investment, literally because there are people that are important to a supply chain or perhaps important to another key aspect of a company. And in order to weather it, I mean, in other words, if I'm relying on 4 or 5 key pieces in my supply chain and I'm losing one of them, it's very difficult to lose that party. And so there are some bankruptcies where that's happening as well. You see a lot more strategic recently. What are the lender benefits and why do people lend? Well, you can receive a premium over normal interest rates. The DIP loans are in amounts substantially higher. They range from 25 to 50% sometimes than the debtor's projections. The DIP lenders profit because they get all kinds of fees in addition to the interest rates. They're typically secured with enough collateral or you wouldn't get into the loan to begin with. You get security and less risk because of the priming lien and super priority claims. The liens are not typically subject to challenge once approved by the court, and you get immediate relief if there's a default to get out of the bankruptcy and then exercise foreclosure options if that becomes an issue. There are all kinds of covenants that you can put into place as well. These are some of them. I won't go into full detail, but one of the ones that's I think the most important may be the strict milestones for the sale of the state assets. You control, as the lender, how the bankruptcy is going to go forward, And if you don't meet a milestone, if the assets of a company or division are not sold by a certain date or time, then you can call that as a default on the loan. So what's happened in Singapore that's so interesting? Well, they approved a different amendment to their Companies Act, and that included major changes to rules governing schemes of arrangement, which you're probably familiar in if you work in the UK or in Australia. Judicial management, which allows there to be sort of a trustee put into place to facilitate things, and also cross-border insolvency, which I think is a key piece of this. The Act also incorporates several features of Chapter 11, including super priority dip financing. They call it rescue financing under the Act. Its enactment was the initial phase in a series of law reforms done as part of a big project in Singapore. Key provisions, the super priority debt and possession financing, of course, is one. The worldwide moratorium on debt collection efforts, which is interesting, just like the bankruptcy code's automatic stay. Non-consensual cram-down schemes of arrangement where you can push a dissident or angry secured creditor down if everyone else in the room is benefiting from the package. And there's also prepackaged scheme approvals. And the interesting thing about on the rescue financing is that it does allow, under certain conditions, if you can't find favorable financing, the ability to incur the priority unsecured, secured, or super priority scheme is very similar to the US. They do not preclude a debtor from obtaining secured or unsecured financing or credit in the ordinary course of business as well. Again, the openness, which is the big thing here, is they've opened it to almost anyone, including anyone who chooses through a choice of law or choice of forum. And they've adopted the model law on cross-border, and they abolished any sort of specialized treatment for local creditors. All those are key. I think with that, I'll turn things over to Ricardo.
Thank you, Rafael. Well, thank you so much for all our friends, Susana, Hugo, Ernesto, and Rafael. And we have some time here for having a conversation with our friends. I think that Rafael explained very well which are the most important features for a Chapter 11 in the United States. Basically, he speaks about the deep financing, the specialized courts that they have, the automatic stay. The cram down also was mentioned by Rafael in his presentation. So I would like to start this round table with asking to Rafael. Rafael, as you mentioned, one of the most important features for filing a Chapter 11 in the United States, and we're thinking as Chile and Colombia to be center for organizations in Latin America, is the deep financing, which is very important for the company when they are filing because they need cash to operate. So the question is, you are half Chilean, half Colombian, as we know. You have a study in the United States, a very important career there. So the question, you know these three systems, Chile, Colombia, and you practice bankruptcy in the United States. So what do you think that we have to work on to have a better deep financing system in order to capture and to have more organization in Chile or in Colombia?
So if you look at what Singapore has done, is they've set a framework or a structure that pulls down borders, and both Chile and Colombia have, with much success, done the same thing legally and regulatory, and in the way that they deal in certain terms of trade with other countries. So I don't think it's very difficult to do some of those things. I will say that money doesn't see borders. I think money sees risk and makes a decision to go in certain places. So some of the things that I thought is important is that you want to be able to encourage different types of lenders to come in. You want both financial and strategic. And I was fascinated by the fact that Colombia, for example, has has a framework which allows for the different smaller size entities. We struggle with that in the United States right now. New subchapter 5 is supposed to take care of entities that were somewhere in the $3 or $4 million range. Because of COVID, it became $7.5 million. There are very few hotels, for example, is a big example. Small hotels that have a wonderful, maybe a franchise agreement, et cetera, with a major brand. If you think that those hotels are not going to have more than $7.5 million, I don't think you understand the hotel business. So I think that fascinated me about what Colombia was doing. I think that the issue with interest rates is a key issue. The reason that people come into DIP financing is because they're going to make more than 6%. If you have restrictions on interest rates, it's going to be very difficult to bring someone there. I think the registration system also helps in terms of, and look, I as someone who studied comparative law, I have a degree from Georgetown in comparative law, and one of the things that we really studied there when we were looking at the civil law system, the idea of registration, the idea of documenting, et cetera, that should bring some, if you can deal with the risk issue, I mean, with time, if it takes too long, but that should bring some real security to a lender, that you have a system based on that type of registration. I think that those are the types of things that would be the most key aspects. And again, I thought it was wonderful, the different things I heard both from Hugo and from Susanna on the changes in both countries.
Thank you so much, Rafael. And I would like to follow with Susanna from Colombia. And one of the most important things that also have the Chapter 11 system in the United States is the possibility to reject contracts. It's the cherry picking that we know is in our insolvency talk. But and we as Chile and Colombia, we have the same civil code, and as a principle, both sanction the idea of the sanctity of the contract. So the question for Susanna is, how do you think it works, or if you have this feature in Colombia, the possibility of the debtor to reject contracts?
Thank you. That's a very good question, Ricardo. Well, we do have rejection of contracts in bankruptcy. Of course, we come from the same civil law tradition, but under Colombian bankruptcy law, it is possible that during the Chapter 11 or the reorganization, the debtor requests authorization from the court to terminate contracts, but there are some standards that must be met. So it must be an executory contract as they know them in the US. It means a contract that is of still performing, not a contract that is already done. It must be performing. Also, the debtor must show that the contract is very expensive in comparison with other alternatives, and that it tried to directly negotiate with the debtor, with the counterparty of the contract. If those standards are met, the bankruptcy court could authorize termination. This doesn't mean that the bankruptcy court terminates the agreement, and I understand it's very similar to the US, because what this means is that any damages for termination or for early termination will be subject to payment under the reorganization plan, but any discussion on the amount of damages must be done before the natural courts. If the parties agreed upon arbitration and they do not agree on the amount of the damages for early termination, they could go and litigate this out of bankruptcy, and the amount to be recognized will be subject to the reorganization proceeding. The main power of this rule is that the damages are going to be paid under the bankruptcy rules. It's not a post-petition claim or an administrative expense. So that is why it's very important to get authorization from the court. If there is no authorization and the parties early terminate the contract after the commencement of the proceeding without the court intervention, the damages could be an administrative expense. So the short answer is that we do have rejection of contracts, and I believe that our rules are kind of similar to those in the Chapter 11 regulation.
Thank you so much, Susana. Very interesting for us. As we explained the same civil code, the Código de Bello. We don't have the possibility to reject contracts in a reorganization plan in Chile. So this is very interesting to know that a civil law country as Colombia has this alternative in this proceeding. And I would like to follow with Hugo Sanchez, who is our superintendent of the insolvency agency, a very important superintendency in these proceedings. So I'd like to ask to Hugo, what do you think? Which are the attractions that Chile offers for the cross-border insolvency proceedings? Huh?
Yeah, well, it's a very good question, Ricardo. I think the answer is it has two different dimensions. One is that, first of all, we have to transform into a center of main interest of big companies. I think that we have made a very big effort as a country with many different laws, with financial market law, number 1, number 2, number 3, to become, a financial area, financial platform, and a platform for big companies. So we have a political stability, financial market stability, transparency, etc. But in terms of the second dimension, or insolvency law, we have a legal invariance. The insolvency law is not amended frequently. The Chilean bankruptcy regulations are widely applied by the courts transparently. It's very clear and it follows good international practices. Debtors know with certainty it affects the assets, they affect the way to resolve their conflicts and the practice of the courts. It contemplates limited processing times. We would like to have more limited processing times where we audit all the insolvency proceedings to achieve that goal. In reorganization, the procedure establishes broad freedom for the contracting parties to establish clauses, guarantees, and there is a mechanism to maintain the supply of these companies. And finally, to answer your question, Ricardo, in the case of liquidation, this is very controverted right now. The discharge of the debt is at the end of the procedure, extinguishing all the unpaid debts automatically. You know that many creditors don't like this automatic discharging proceeding, but it's very good for, especially for individual, as a very humanitarian help. Thank you.
Thank you so much, Hugo. Yeah, this is something that is in court. The discussion is how the extension of this discharge. It also eliminates, for example, the surety, the personal warranties of third parties. So this is in discussion. I would like to follow with a question to our friend Rafael. We have here our friend from Colombia and Chile. We have been participating in Chapter 11 cases with representing creditors that are located here in Chile and they file in the United States. And one of the most important effects of the Chapter 11 that you explained is the automatic stay. And the question that we have here as a Chilean and Colombian attorneys is the effect of this decision and this effect of the law. If this decision of this effect of the Chapter 11, this automatic stay, has extraterritorial effects. So I don't know which are the trends that you have seen. For example, I don't know from which if the Chilean creditors or the Colombian creditors, they fulfill this automatic stay of they follow with the execution, etc. So which are your view or your experience on that?
So I love the fact that it's the worldwide stay. And I think that when they say it's a worldwide stay, they really do mean it. The problem is that the worldwide stay by itself doesn't give you much, because it's really a territorial versus universalist approach to how you look at insolvency. And if you have a universalist approach where, like under our model law, you designate someone to be the first main bankruptcy court, and then other courts facilitate what they do, and you have a treaty, or you have, even without a treaty, you have an internal policy that says this: we're going to honor the other courts, whether it's through recognition or a much more open border than others, or whether it's because you're going to facilitate and use comity and other principles of international law to facilitate the working between different courts. The worldwide stay doesn't help unless there's also participation in the model law or some other version of it. I think that it fails. However, if you're a very large country, or if you have all the assets in your country, then there is an effect that worldwide stay does cause an issue. And it's but I think that if there is not, the sovereignty of each country is going to determine exactly what happens in those situations. There are other business considerations that are come into it as well. Even if I can't get hit by the worldwide stay, that may be that I want to work in the United States. I don't want some judgment hanging over me or some sort of contempt. I also want to make sure probably that I stay as part of this enterprise. I mean, if you understand how an airline works, an airline doesn't work just with planes in the United States. You have to go from one place to the next. And there are places that receive, well, cargo and people and everything else. So I think that the worldwide stay, you have to, I say it with a little bit of a smile. It's not that it isn't a very important factor, but I think for it to work in a cross-border context, I think it's very important in a cross-border context to be part of that larger enforcement mechanism that's out there.
Thank you so much, Rafael. I would like to ask to Mr. Hugo Sanchez. You mentioned in your presentation that Chile was working in different amendment of the law, trying to, you said, to give some deadlines more flexible to allow better negotiation, to create a reorganization scheme for small companies, and have more extension of the financial protection of the entities which is under reorganization, and to improve the deep preference that a creditor can have in this proceeding. So I would like to ask you, Hugo, if you can share with us which you think that the next changes that we should have from our legislation of insolvency legislation to improve our law, to have Chile as a main center for organization in Latin America.
Yes, well, our main efforts with the Ministry of Economy has pointed to resolve the pandemic effects over the almost 1 million small and micro businesses and individuals. So our focus was put in place in terms of the reducing the stages of the liquidation, reducing the cost of the reorganization that is very expensive especially for micro and small businesses. And the idea was having new insolvency proceedings to probably diminish the total duration of the proceeding that is nowadays an average of 2 years to 8 months. And well, I think that there is another dimension that it's typically forgotten, that it's financial education. I think that a good law, a good insolvency law with very efficient and effective reorganization and liquidation, especially reorganization, is nothing if we don't have a financial education as the basis for increasing the number of reorganization and making them successful. especially for our SMEs. Why? Because they don't have the tools, yeah, they don't have the money to pay tools, knowledge, advisors to detect insolvency on time, to make the decision to reorganize at the appropriate time. That is why we have a financial education program, a financial education webpage with insolvency calculator to help SMEs and individuals. We have two different insolvency calculator to detect insolvency. We have a very extended education, financial education programs the last 3 years with the help of many other public and private institutions. And well, I mentioned that some changes of probably of the banking law to the compendium of accounting standard of the banking of banks that Financial Market Commission applies, like the law 18,010, the article, specifically the article 6 ter, to allow to raise the maximum interest rate to permit those lenders that finance, especially insolvent companies. In Chile, they are not able, we have a not very deep financial market, so we can attract those lenders abroad and to be established here in Chile as an agency to create a very more deep market. I think that, and finally, to have specialized courts. I think that it's very expensive probably to have a bankruptcy courts, but we can support those courts with a more extended educational program from the superintendency and other actors. We have a round table with those other interest parties. I think that we have to become more closer than we are the recent years. That's it.
Thank you so much for your complete answer, Hugo. And I would like to follow this with to Susana, if it's available here. You mentioned, Susana, that you have in the Colombian insolvency regime some features of deep financing. So you talk about also the equity swap available in the system. So I would like if you can share with us which are the experience that Colombia has in deep financing alternatives in the last, I don't know, last year, which are the process, the cases that you have there with deep financing.
Thank you, Ricardo. So of course, this is new for the Colombian market. So it's something, or is in itself a business that it has some period to be stable and more common. We have started seeing some investors interested in this deep financing. So this was created as in one of the pieces of legislation issued due to the COVID crisis. We have seen that working in out-of-court cases, those that I explained that are then confirmed by the court. We have even seen deep financing by a bank, which is not what we expected to be happening. But it is also worth mentioning that some of the regulations applicable to banks with regards to new credits to insolvent debtors were somehow relaxed. So that allows the banks to enter in new loans for debtor entities. So the business is starting to develop. We have seen a few cases, but of course, in some of the cross-border cases coming from the US, it's more common to see that. Probably Hugo can tell us about the details of the deep financing in LATAM case. We had also one deep financing case from Canada, the Grupo Pacific engaged in oil business. This was a few years ago in 2016 when the price of the oil dropped. They had about 5.2 billion in debt. They had a lot of operations in Colombia. I would say that the discussion about COMI was that about 70 or 80% of the operations were in Colombia. So why was the reorganization being done in Canada, where there was the holding entity? So it was a prearranged under the Canadian law. There was a deep financing of $250 million. It was, they did an assessment of the value of the company, and it was about $1,800 million. And then as a consequence of the deep financing, 63% of the shares at the end of the reorganized entity were handed over to the creditors, and 37% to the deep lender that accepted to receive shares in payment. And also during the structure of the deep financing, they took security interests over all the assets, even those located in Colombia. So for that purpose, the Colombian court authorized to create those new security interests in Colombia. And as I understand the LATAM case, there was a deep financing of about 1.4 billion in the US, and the time was 18 months, or the exit of the Chapter 11, and there was an interest, I understand, 14%. And they also took security interests of over the assets. So this is starting to look familiar in these jurisdictions. And what I would point out is that sometimes Latin American companies cannot go to the US to engage in these procedures because they don't have enough points of contact. But maybe they have contacted with other countries in the region, like Chile or Colombia. And if the legislations start to offer these measures, there could be a market around this, this situation, which is distress financing or deep financing, which it's kind of a specialized type of financing and type of business. So in Colombia, it is starting to develop, and the surprise is that even banks are starting to get some interests in the business. Of course, the market still has a lot of space for non-distress financing. So sometimes it's harder to get the appetite for distress financing, although there are different businesses. So I believe that with these new regulations and the fact that at the end, the bankruptcy systems tend to be in a way harmonizing and going in the same direction, this could be something good for Chile, Colombia, and the region, because we understand the way that they do in other countries, and that allow us to communicate easily. So basically that's what we are doing in deep financing in Colombia, Ricardo.
Thank you so much, Susana. I think that same situation here in Chile. We are having baby deep financing, and we have to grow up in this matter. And I would like to ask Rafael. Last year, we have a lot of filings in the United States. We have the filing of LATAM, we have the filing of Avianca, Aeroméxico, that they opt for filing in the United States for this structuring under Chapter 11. So now I would like to ask him, Rafael, if you think that this is a trend of Latin American companies, or is just a trend of this kind of entities, which are airlines? What do you think about that?
I don't think it's just the airlines. I don't think it's just the airlines. But I don't think it's necessarily going to mean that every Latin American bankruptcy ends up in the United States. I think that there's a big debate in the United States over what's the proper venue, even within the United States. They always talk about, well, no one should go to Delaware. No one should go to New York. They usually just say Delaware because New York they don't want to beat up on because New York is bigger than most states. But they pick on Delaware. And it was for a long time, if you look to see who was really picking on it, it was Texas, because they were angry that Enron filed in New York. And they had displaced anger. They didn't go yell at New York, they yelled at Delaware. Okay, fine. The fact of the matter is that's calmed down because now there are a lot of cases that are filing in Texas. Not just oil and gas cases, but JCPenney filed there. A very large retail case. Other retail cases filed in other jurisdictions. There were big cases that filed in St. Louis, where my main office is for Armstrong Teasdale, that were involved with the Abengoa and Evidenza cases, which was a worldwide case. I think that the reason that people file in these jurisdictions is because it's very difficult to understand where the home headquarters is and whether it's even relevant, right? When the creditors may be all over the world, where the financing might be in one place, but it really isn't. Financing's interconnected. So I think that the size of the case, and I think that there could be geographic opportunities. I think that's why Singapore believes that it has a very good shot at capturing. Singapore probably has a better shot of capturing the next large Latin American case. I'm not saying right now, but let's say 5-6 years from now, because Singapore, when it becomes determined to do something, they do it. And I think that they might be the most attractive place because of the relationships. There are deep relationships between Latin America and Asia, and particularly places like Singapore. And so I think that it doesn't necessarily mean that it's by industry. I think it's by size. I think it's by complexity. I think there are other geographic considerations that come into it. And I think that it's good for companies to have a choice as to where they file. It may be that Chile and Colombia become the perfect place to file for a variety of different reasons. There may be labor issues, there may be others. Even in the United States, if you look at a case like Toys R Us, no one would have ever dreamed of giving workers severance and it coming from the dip financiers without there being a legal reason to do it. Yet it happened there because in order to get the plan approved and whatever happened there, the judge felt that that would be a good way to change things. Same thing in Sears. There were several concessions given by the lenders in Sears that didn't exist in other places. And who would have ever dreamt that the largest or the chair of the unsecured creditors committee in JCPenney would then join up with the secured creditors to buy the company? But the facility of those different negotiations, I think, are the most interesting aspect of where somebody needs to file. Where you spread things around, I think, to allow for that negotiation is going to be the key place for people to file.
Thank you so much, Rafael. It's not just airlines, I'm clear. Huh?
That's right.
And to Hugo, I would like to ask him, Hugo, we have last year here in the pandemic era, a lot of very important cases in Chile. Example is ABCDIN, AD Retail, Enjoy with our recognition proceeding in the United States. So they are more complex cases yet by year. And for example, there are hypotheses of deep financing with convertible debt, the issuance of bonds, etc. So the question is from the service industry. How do you think this is the service industry in Chile? The audit, the lawyers, the people that help the finance and define the company. Which are your thoughts on this?
Yeah, well, the insolvency market has been growing since the insolvency law came into force. As you mentioned, although the pandemic did not imply a substantial increase in the number of procedures, many authorities, directors, and interested parties said that it will be during the pandemic and after probably hundreds of thousands of companies and individuals filing for insolvency proceedings. It didn't happen. But on the other hand, it involved more large companies subjected to these procedures because they wanted to protect employees, to protect the assets, to protect the whole value-added cycle. So although there was no practice regarding financing within an insolvency proceeding of companies of this size, in many of these procedures, the financial advice was very adequate, achieving high-quality agreements. I think that this is, we can see the effect of these high-quality agreements because of these financial advisory service, professional services that are getting better, they're increasing, and I think that the number of reorganization will continue increasing in the long term. You know that last year it increased in 21%, the greater percentage of, in the case of reorganization, and probably the interest of the stressed lending industry will increase too, and this attract parallel professional and advisory services will be necessary too, I think, of course.
Perfect, thank you so much. We are, I think we have a few minutes, and Rafael mentioned the possibility that Singapore could be a center for Latin American organization. And from a practical point of view, I want to ask to Rafael, how do you think in this competition that we have now, how do you think it worked, the language, the time zone, or the judicial system, common law, civil law, as a via country to have these cross-border organizations?
So I think that the critical thing is the openness of the system. And again, I think I mentioned before that Chile and Colombia have a very open system. You saw that the Singaporeans put in there as one of the things, even if it wasn't true or even if there was something there, they said, look, if you come here, you will not get treated differently than someone who is a Singaporean citizen or a Singaporean entity. I think that is critical. I also think that the issues of geography are not as, I mean, look, nothing has stopped Hong Kong and Singapore, for example, from running things all around the world, or New York or any other place that is central. I think that, you know, one of the things that came up about length of time, I mean, that's even an issue that somebody could say in the US sometimes isn't as competitive. Yes, there's a lot of time, but you used to have much longer bankruptcy cases, and then there were changes in the US law. The Canadians took, I think, advantage of that in some sense. There's not as much, I think, large deal flow in Canada, but their system is a little more progressive in some instances in terms of time. In other words, you can have too much time or too little time, depending on the situation for a bankruptcy. But I think that one of the issues that often comes up is whether or not the civil versus common law is an obstacle. And I think if you look at everything that Susana wrote up about what they've done in Colombia and the desires and the things that have happened for the Hugo said in Chile, I don't think that's as big as an obstacle. I think that the commercial law system that is codified in the US anyway, it's very similar to the civil law system. I think that there have to be some strategic rewriting of the legislation, but I think that without legislation, the judges, it doesn't matter how smart your judges are or how professional or how big a problem solvers, if they don't have the legislation in place, you can't do it. And I see no distinction between civil and common law in that respect.
Thank you so much, Rafael. We have now the last question, and I would like to ask just if it can be answered in just 1 minute, and I'll start with Susana and also with Hugo. And Susana, now we are in a COVID situation, thinking in the post-COVID-19 scenario, what do you envision that the companies in Colombia will work, and how do you think that if the Colombia has to improve the reorganization scheme, thinking on this post-COVID-19 era?
Thank you. Well, that's a great question, and it's hard to forecast for companies post-COVID. No one would have been able to forecast companies in COVID, and any forecast would have been inaccurate. But I believe that as long as the vaccination starts to be spread in different countries, this will start to reactivate the businesses. Of course, entities devoted to tourism have been very affected, but there is a lot of appetite to go again and have fun. And you should just watch the beaches in Miami full. So I believe that they are going to start recovering. Of course, the loss for these years will take some time to get somehow covered, but probably I believe that in the following 2 years, it will be key to know which companies made it and which companies were able to reinvent the business and keep afloat with their activities as a going concern and as viable entities. And of course, this will also end up with a lot of liquidations, both private and judicial. So probably a lot of companies will try to reorganize judicially and then end up in a liquidation. But what we are seeing is that some of the smallest entities liquidate privately and voluntarily without going into an insolvency proceeding. So I think that the structure in the economy will have some changes. But I think we have to see this as a great opportunity to sophisticate our systems, to see how to balance the rights of the parties, because those systems that are very pro-debtor or very pro-creditor do not create an environment to reach negotiation and transactional solutions to the insolvency. So at the end, the judicial system cannot cure the insolvency. What we have to do, and what Rafael was pointing out, is that if you have a legal frame that allows to get good solutions, this crisis, it's a great training for judges and parties and the countries and the economy to take businesses out of bankruptcy and also liquidate fastly those that need to be out of business.
Well, in the Chilean case, Ricardo, because of the pandemic, because we were thinking about what is going to happen after the pandemic, we amended very fast our law in 2.5 months. And the idea was to give the individual, and specifically the MSMEs, the opportunity to file in an insolvency proceeding easily, with very reduced costs, very, a short duration, to be prepared to re-entrepreneur. And on the other hand, as I mentioned, the financial education is very, very important to get those companies or those individuals to be more closely to the reorganization than the liquidation. A big focus, a big pillar of this law amendment is that we want to switch the numbers, to have more reorganizations of companies, more renegotiations of individuals, and finally less liquidations. But we need a very important financial education program to get them with the tools and with the knowledge to very early file to these reorganization and renegotiation proceedings. That's it.
Thank you so much, Hugo. Ernesto.
Yes, well, we are running out of time. It was really, really interesting. And I want to really thank Susana, Hugo, Rafael for your time, for all the discussion. Very interesting. I would say it's really challenging for Chile, Colombia, also another country that must be a world-class center in insolvency cases. So there is some road in order to move forward. So quiero agradecer a todas las personas por su tiempo. Estén en contacto porque vamos a seguir haciendo seminarios en este tema tan interesante que es el tema de la insolvencia y el reemprendimiento. Thank you y muchas gracias a todos.